So we've had a pretty remarkable 10-day span for the firm in the courts of appeals around the state, including a great decision in Division 2 here, kind of in the southwest Puget Sound area, on a case called McClain, where we represented first responders, specifically state patrol workers who've been working overtime without getting paid for that. And we had a great decision on that. And then we had a great decision in the Supreme Court this morning.
Yeah, we had a decision in MR versus state, which held that Washington's statute of limitations for childhood sexual abuse applies to abuse that continues after the age of 18, and we are elated for all the survivors that will benefit from this decision and our Supreme Court in helping the law catch up with these common sense realities of childhood sexual abuse that experts and survivors alike recognize.
So this decision in the MR case this morning in front of the state Supreme Court, which was 8-1, right?
Yes.
Was a great decision that helps us in a lot of cases. For example, we had a case, our case up in Everett School District with the AP teacher. There was an AP teacher up in Cascade High School who was grooming his seniors in his AP English class, and he was very calculating, this predator. He would groom them, he would spend tons and tons of time alone with them, he would invite them over to be his babysitter, and then when they turned 18 years old, you remember, right? 18 years old, then he would begin hardcore sexual pressing on them, sexual abuse. We had another one against Seattle Prep's athletic director within the last couple of years, where he too was picking out his favorite softball players, his basketball players, others, and then he would groom them, and then when they graduated, he would actually wait till the graduation, the senior party night, and then he would press on them for sexual contact, sexually abusing them. This decision by MR opens up those cases and what you can recover on those. How?
MR holds that when sexual abuse begins before the age of 18 and continues after the age of 18, that abuse occurring after the age of 18 is recoverable. It is an injury that flows from the grooming and the sexual abuse when the survivor was a child. And it's a remarkably common sense proposition. Survivors, anyone out in the world, experts in childhood sexual abuse, know that the end goal of grooming and sexual abuse is more abuse and continuing abuse and escalating abuse.
Now, one of the questions though that you faced in the Supreme Court hearing was what constitutes sexual abuse before you turn 18, right? Is that grooming? What's grooming versus sexual abuse? What can you recover for as a child under the child sexual abuse statute? And then how does that continue into adult? How does MR factor in on that?
MR factors in because when it holds that when there's an act that would qualify as a sex crime against a child, which can be anything as severe as sexual contact, something that may initially seem innocuous, but we all know it is predatory and that it is absolutely harmful, such as touching a child in an intimate area of their body, kissing them, like touching them with their hands. That can qualify as a sex crime, and that is what leads to continuing worsening abuse and opens the door to recovery.
So, speaking of questions about that, what constitutes a sex crime? Does somebody have to have been prosecuted for something like touching the top of a breast, or is it just the act having occurred could have been considered a sex crime?
Yeah, it's the latter, because fortunately Washington has some of the best law in the country on the subject, and it recognizes the reality that most survivors don't disclose their abuse at all until later in life, and many, if not most, don't seek criminal prosecution due to the effects of the abuse. It's just so hard to come forward and go through that process. So Washington doesn't require an actual criminal conviction to say that there was a sex crime that occurred when they were a child. That's something that can be established in a civil lawsuit.
Good, because as you know, as we see the puffs of smoke up from the Vatican, priests for 100 years have not been prosecuted in Washington State or anywhere else for horrific sex crimes, right? And yet we can still bring the claims.
Right, right.
So one of the unanswered questions, at least I think it's still unanswered, is if you're being groomed and there's these sex crimes occurring as a child, can you also recover? Let's take the group home cases, because we know these really well. You've got group home children who at 17 are being sexually abused and also physically tortured, maybe as a part of keeping them quiet for sexual abuse, maybe just because people are sadistic. Do you get to recover for the physical abuse that goes along with or occurs kind of in the same time period as the sexual abuse? Or is that unanswered?
And that's an issue that sitting here today is unanswered. It's certainly one that PCVA will be leading the charge on in Washington and everywhere we can.
It seems common sense that you could.
It is common sense, and under the language in the MR opinion, it certainly seems that the court recognizes that there are all sorts of injuries that are a result of childhood sexual abuse. And as experts in the field tell us over and over again in cases, is that coercion and that desensitization to abnormal abusive behavior that you get in sexual abuse that leads to a survivor not resisting subsequent abusive conduct, and that certainly would include physical abuse. They've been conditioned not to resist, they've been conditioned not to tell anyone, they've been conditioned to internalize that this is somehow acceptable, and that would include physical abuse as well.
So MR is a really important decision. I hope you get a chance to read it, but if you don't, quickly summarizing it, we have a client who was a wonderful basketball player, great basketball player, who was being recruited by Yakima Valley Community College, might have said that wrong, but was being groomed almost from the very get-go in the recruiting process, and then was groomed into sexual abuse later on into adulthood. Super brave client. This has been a long, hard journey on her and her family. They got to attend the Supreme Court hearing to watch Chris go. Wonderful experience, and of course we were all hopeful walking out of the Temple of Justice down in Olympia that day that it would work out like it has today. Great decision, 8-1, wonderful concurrence by the way, and we're very proud of that result.